Welcome, everyone. This is the session number 6 of our decolonial reading group. And today, with the help of our guest speaker, Dr. Anna Hankings Evans, we will be focusing on nothing less than the decolonization of international law. The project of decolonization always leads to new approaches, which is why this reading group is conceptualized as interdisciplinary as possible, assembling brilliant minds from all kinds of different academic backgrounds. And today, our group is composed of literature and philosophy scholars, as I can see in the participants, as well as law faculty and human rights professionals. So I guess we can be very much looking forward to the discussion later. Dr. Anna Hankings Evans, who will be leading us through Antony Anghie's argumentation today, studied law at Albert Ludwigs Universität Freiburg, Bahçeşehir Üniversitesi Istanbul, and Freie Universität Berlin, where she also worked at the Institute of Public Law and Public International Law. Anna specialized on bilateral investment treaties between China and African states, and in this context completed a comprehensive research stay at the Center for Chinese Studies at Stellenbosch University in South Africa. As part of her legal training, Anna Hankings Evans engaged in a legal traineeship at both the German Federal Ministry of Economics and Energy and the German Embassy in Accra, Ghana. Anna currently works at Alexander & Partner in Berlin, where she's primarily involved in international commercial and investor state arbitration proceedings and advises in the field of international contract and corporate law, as well as in the design and implementation of cross-border investment projects with a focus on Africa. So with Anna, we finally have a guest speaker from the real world beyond academia, if I may say so. And I'm sure the audience will appreciate this, as many of the participants in this group work as activists or in NGOs or as legal advisors for refugees, like Kelly Ward, for example, who's part of this group. And then there's also Estefania Cuero, who will be joining later today, who, for example, even has developed her own workshops on diversity and intersectionality. So everybody is involved in realms outside of academia as well. As always, after the presentation, we will have time to enter into discussion, and please feel free to ask any questions or to comment in any of the following languages: German, English, French, Turkish, and Twi, as Anna speaks them all, which is one of the reasons for why she has translated Antony Anghie into German. Anna, thank you so much for taking the time and sharing your insights with us today. It is really a great honor and pleasure to have you here today. Please join me in welcoming Anna Hankings Evans.
Thank you, everyone, and welcome to today's session and lecture and discussion, hopefully, on decolonization, neocolonialism, and human rights. Human rights as a possible outlook on the solution of how we can reframe a post-colonial law, or what that would look like. And I would ask you to engage in that conversation. There is no right and wrong. And if there is one thing I can today give you on your road of, or as a point of departure, is that law is an opinion. If you write a law exam, there will never be a comment written like this is a wrong answer, because there is no wrong answers. It is an opinion, but in the end of the day, still a certain opinion will prevail. And even in legal discourse, in academia, or in scholarship, in practice, there is always a dominant opinion and a guiding dogmatic that most lawyers apply. So I'm very appreciative to TWAIL, which is Third World Approaches to International Law, because they broaden my horizon and my perspective of how we can maybe reshape the conversation around law, and how we can enter into discourses about certain opinion, and how we can dissect them from what is a known fact, because that's also something lawyers deal with on a regular basis. Yes, international law to start with the definitions, everyone is on the same page, is generally defined as the law governing relations among sovereign states. That's already the first issue we will be discussing, sovereignty of states and the consequence of sovereign equality of states, which means that every state that has sovereignty is considered equal under international law. International law is to differentiate it from national law in the sense that there is no sovereign authority or no authority implementing laws against, let's say, us, the citizens. We don't have a state or an overall operational body that guides international relations. It's what states have bound themselves to and what they want to pursue and have the power to do so, which is a significant factor, which third world scholarship highlights. So why does the question of coloniality continues to play a role in international law? If we take international law, colonialization and decolonialization is an accepted fact throughout scholarship. There is no one contesting it as a fact, but it is a matter of how we interpret the fact. Was it a civilizing mission, or was it a disruption in power that still shapes international law and relations today? And this brings me also to my very personal venture of international scholarship and legal scholarship, because in the end of the day, it is always about your own biography and how you locate yourself within the system and what your role is within the system. And as a lawyer, it is intrinsically important that we understand what we do, what we apply, and what outcome it has on the real world. In that sense, I would like to introduce the author, Antony Anghie, that is today's subject of this lecture, in the sense that he has published 2 texts that I want to discuss with you in detail. And while I researched him, I found an interesting quote that he gave, and it gives a little bit of an insight into who he is and what kind of thought process motivated him to enter into third world scholarship. It was an interview that is published on the website of Kent University. And in this interview, he said, "I suppose all scholarship is to some extent autobiographical. Growing up in Sri Lanka, I did not really think much about issues of colonialism, but I did have a vague sense that I was from this thing, the third world. I was also conscious of the fact that I was part of a very privileged elite in Sri Lanka. It was only in Australia at university that I began to systematically explore some of the basic questions that had puzzled me as a boy in Sri Lanka. Why are some countries rich and other countries poor? Why were some people rich and others poor?" So this is also a guiding question that followed me throughout the course of my research. I dealt with bilateral investment agreements between African states and China, 2 states that are considered of the global south. But how do we deal with power imbalances? And does a South-South relationship necessarily mean that these relationships are more just? Because in the end of the day, inequalities and international law is intrinsically linked to the question of global justice, and also will play a prominent role in future years. And especially now during the pandemic, we've seen a rise in global inequalities among states, but also within regions and within states. And Antony Anghie is one of the famous legal scholars that is considered of the new generation of third world scholarships that emerged at Harvard Law School in the 90s, where they wrote a manifesto and with the intention of outlining the power dynamics that still persist in contemporary international law. Prior to that, though, there were early third world scholars right after the decolonization and in the course of the Bandung Conference between African and Asian states in 1955, that was seen as the birthplace of third world scholarships and the positioning of third world states, or today we would call them the global south, within the whole framework of international law, and to bring prominence to their positions to certain concepts and doctrines. Today, I would like to highlight some of the issues that we are dealing with or that international law has not overcome yet in being considered a truly post-colonial international law. But maybe we can together in a debate engage into a conceptualization that will maybe bring us closer to an idea what a post-colonial international law could look like. So I've mentioned earlier that my main field of research was international investment law. And a lot of third world scholars have dealt with international economic law specifically, because that's where the power lays that might contribute to richer states and poorer states, more powerful states and less powerful states. And we're still in a process of conceptualizing it, what it means to analyze power in international economic law. International investment law, but I will speak about this a little bit later, is born out of the colonization mission. That means the system that we have in place now was established for a purpose. And the purpose was to safeguard colonial assets of colonial powers in now newly independent states, now decolonized states. So it also was a vehicle of safeguarding certain power dynamics and power relations. The starting point of international law is the concept that every state is sovereign. Every state, and sovereignty means every state can act within its territory the way it wants. So what is a state? If we look at the theory established by Jelinek with the three elements of what constitutes a state, it consists of a permanent population, a territory, and an effective government. International law as such does not say what form of government or if it has to be a democracy. In modern times, there is more and more, one could say, a right to democracy crystallizing, but it's not really common opinion that such a right exists. So basically, these are the criteria. In Antony Anghie's text, he powerfully outlines how certain societies were not deemed states, although there is a lot of literature on the fact that they would technically constitute states if one would have applied the same criteria to these entities. But instead of acknowledging that there are states, one went to other factors that could differentiate Western nations from then colonialized nations, which was culture and which was civilization. This is why colonialism has also been described in international law as the civilization mission, meaning that in the end of the day, it benefited these people in the colonies, and by bringing to them, by conquering and occupying these territories, they were brought into the realm of international law. Thus, it is now considered universal. So we take the fact colonialism, but it can be coined and interpreted in different ways. Was it an oppressive regime, or was it a liberating moment, which then in the end opened up to the whole world the concept of international law and welcomed them into the family of nations, so to speak. And the family of nations, or the League of Nations, was also a common term coined in international law. The organization League of Nations was the predecessor of the United Nations. And the United Nations was also an organization that put into law certain power relations before other states entered into the family of nations and could join. So we have a fact, and then we have the problem of how to interpret it, in retrospect, although we have a lot of historic evidence, and we have a lot of historical publications that indicate that there was a certain level of inferiority assumed with regards to people in the former colonies. So sovereignty is a concept that developed in the course of the 30 Years' War, and that ended with the Westphalian concept of sovereignty, but it only applied to Western states. And that is the first, I would say, deficit of international law. It didn't develop with the participation of all states. It developed with the participation of some states, and it then expanded in whatever way, legitimately or illegitimately, but it expanded throughout the world. And then later, newly independent state had to abide to a set of rules that they did not create and had no influence in creating. And this is essential, because it also brings us to the problem of how to deal with power and law. There have been many doctrines in international law, and Antony Anghie, in his first text that I'm discussing, Towards a Postcolonial Law, outlines certain doctrines that helped international law maintain a certain power structure. So first of all, it is the differentiation between civilized and uncivilized nations that he points out in his text. So nations were deemed civilized and uncivilized, and the standard they were measured against was a European standard. So we could say we all now overcame it, the decolonization, and we can now reset, and now every state is anyways considered a civilized nation. But there is still evidence in international law today that there was at some point certain societies considered uncivilized. For example, if we look at the International Court of Justice, one of the 5 organs of the United Nations, it has a statute that was written in 1945 or came into force. And in its Article 38, which is arguably the most important article in the statute, which prescribes which sources the court can apply when judging a case. And it states that the court shall apply the general principles of law recognized by civilized nations. So there is still evidence in different legal texts that there was once a differentiation. And I remember when I was studying international law, it was the first moment when I stumbled over a wording, because my question to my lecturer was, what are uncivilized nations? And then the debate started, well, just disregard this. Every state today is considered civilized. This is true, but it is an evidence of certain power imbalances that once prevailed and perhaps still prevail today. So how could we solve colonialism in its application in law? We could then maybe just state, we could interpret it in considering colonialism as a factor that differentiated between certain states. But in legal methodology, history only plays a subordinate role in interpreting rules. And history is only confined to the immediate history of a contract. So anything that was going on in the negotiation of that contract is considered the preparatory history of said contract, but not anything of any historic fact of how the system came into place in the first place. So this is where one could argue, well, maybe it needs to be broadened in the way we interpret treaties. And this is also something that Antony Anghie touches upon. So sovereignty, as I said earlier, was the differentiation between, was initially framed as something that every state would entail. However, if we look at historic documents, it becomes clear that there were certain mechanisms in place that allowed scholars to deny sovereignty to certain entities. If you've studied the first text towards the post-colonial law, there are some excerpts from Vittoria, a scholar, not a legal scholar, but nevertheless a guiding scholar in establishing certain doctrines, such as the doctrine of sovereignty and such as the doctrine of natural law and how to deal with native societies. And his argumentation, to summarize it, was that firstly, European nations have a natural right. There is a natural law to trade and travel, which means native societies did not have the right to protect their territorial borders, because in naturalism, which Vittoria deemed as the right law to govern these relations, natural law didn't grant these societies the right to defend themselves. So European societies had the right to travel and trade, which was also supporting the mission of imperialism as such, to expand and to exploit resources. And with these concepts and doctrines, there was a way of justifying this mission. Then there was also right to war that Vittoria coined. And it means he's basically stated that the Spanish have a right to war if hostilities are expected from the native societies. So once the native societies would defend the territory against the natural right to trade and travel, then the Spanish could use war in order to defend their right. So in international law, there is this concept that every state is sovereign and independent and equal. And in order to defend that, you have a right to self-defense. So naturally, any entity, even native societies, would have the right to self-defense. And here is where culture comes into play. Vittoria stated that the Spanish have a right to war. And he also stated that the natives don't have a right to self-defense because they have a different culture. So this cultural argument, which is very familiar in a lot of fields of studies as something which was manipulated into deeming certain societies inferior to others, was again also in legal scholarship used as an argument to wage war against other territories. Then after this natural law period came many other intellectuals, such as also Grotius, which was also mentioned in Antony Anghie's text. And Grotius, while he was not, he's not known as being the legitimizer of colonialism, nevertheless, his concepts were also used by colonial power to justify their expansion into, for example, India. And it is no coincidence that he was employed by one of the big companies, colonial companies, as a businessman. So as you see, we have these doctrine and these concepts, but they always served a certain purpose that was needed at that time. Not to say that they were complete, or that they have no value today, or that they are completely to be disregarded. But we always have to understand, especially with regards to law, that law is an opinion, and different entities have different opinion, and which opinion prevails is a matter of power and of the one that can write the story, so to speak. And there is an African proverb that says, until the lion learns how to ride, the story will always glorify the hunter, which means that it's also a question of who is writing the history and who has the power to deem its own narrative the prevailing one that is then taught in law school and so forth. And third world scholarship is still struggling to be accepted as something else than a very marginalized opinion and a disruptive one. So after natural law, another very significant doctrinal phase in international law scholarship, but also in just general legal scholarship prevailed, and that is positivism. And that is still the conceptual idea that guides our understanding of law today. Positivism in international law meant that there is no natural law guiding relations anymore. There is just sovereign states, and there is no higher sovereign above states, which gave states even more power to implement their views. And again, doctrines of sovereignties were used during positivism, most notably by John Westlake in his test of civilization of governments, which was then again used to justify colonialism. In his opinion, Europeans or settlers that entered into colonies, they were used to a certain standard of governance. And so they were accustomed to such. So in cases where the different standards, where one standard deviated from the other, usually from the Western, it could be replaced. And this was argued to be also in the benefit, or to the benefit of the people of the colonies, which means that now they were brought into the realm of a functional and civilized governance, which would be also in their own interest. So again, it's how we write stories and how we then use to certain doctrines and concepts to justify certain ventures. So what is the consequence to international law out of these historic developments in legal thinking? International law, as Anghie coins it, can be maybe rather understood as an ordering structure between cultures and not between sovereign entities, because what is considered a sovereign entity was not always applied in a uniform or in a unified matter. So there were different conceptualization of sovereignty, and in the case of native or indigenous people, the concept of sovereignty was altered in order to legitimize a certain conquest. Power also still remains a crucial factor in international law, especially in light of its institutions, which can be seen in a quest for a new international economic order, but also in the institution, in the United Nations as an institution that on the one hand enabled decolonization because it gave a platform. On the other hand, it already existed during the colonialization or prior to the decolonization of newly independent states. And the forum where one state has one vote, which really embodies the sovereign equality of states, the United Nations General Assembly, only gives recommendations. So the only body within the UN system is the United Nations Security Council that consists of 5 powers, none of which is of, let's say, Latin American or African origin or reserved for a country, at least when it comes to the 5 permanent veto powers. So again, there is a certain power dynamic established pre-decolonization, and it effectively hinders any quest for a change of the current structure and system, such as initiatives of third world states wanting to establish a new international economic world order that put more emphasis on collective rights in contrast to individual rights, and that constrains private power in contrast to human rights doctrines that doesn't bind private corporations, that doesn't apply extraterritorially, and that doesn't apply to international organizations such as the IMF or the World Bank or other institutions that are still deeply engaged in regulating economic relations that involve developing states. I would like to read out another quote before we go into the discussion of the text. And it is a quote that that also really shaped my legal thinking. And it is authored by Abi Saab, who is a professor that is considered of the first generation of third world scholars. And it's contained in his publication, The Newly Independent States and the Rules of International Law, an outline. And it was written in 1962, so really the first generation of international scholars, voicing opposition and also trying to conceptualize the views of third world states or the global south. And yes, I'm just going to read it out. It's basically the introduction, and it states that to some jurists, the question of the attitudes of a group of subjects of a certain legal system towards the rules of that system might seem irrelevant. For it is agreed in legal theory that legal rules are of an objective matter. This means that they have a content which is the same for all the subjects of the rule, as well as an independent. Oh, sorry, I need to read that again. Let me start again. To some jurists, the question of the attitudes of a group of subjects of a certain legal system towards the rules of that system might seem irrelevant. For it is agreed in legal theory that legal rules are of an objective character. This means that they have a content which is the same for all the subjects of the rule, as well as independent of the subject's attitude towards that rule. The subjects of a legal rule are bound by it, even if they are ignorant of its existence. In municipal law, the application of legal rules is entrusted to specialized organs in order to guarantee their consistent application and prevent individual and subjective interpretation or qualification of them. Such an analytical presentation of the legal system should not be taken to the extreme, however. It is perhaps useful from a pedagogical point of view and does help to avoid the confusion of rule and fact. However, the analytical independence of legal rules does not mean that they are completely immune from social pressure. For one thing, they are applied by men whose conceptions of them might differ. Moreover, rules receive different interpretations as social conditions change. Finally, an unsatisfactory rule can be repealed if its recipients have enough social power to influence the legislative process of the legal system. Rules can even fall into disuse without being formally repealed. What does this mean? It supports, in the end, what Antony Anghie and many other authors and what I have also dealt with in my research. It is the accusation of not being objective, whereas we have been told at the same time that legal opinion is exactly that. It's only an opinion, and it always may change for the better or for the worse. But it depends who has the power to influence legislative processes and maybe how we conceptualize certain doctrines in law and in international law specifically. And human rights, I do not want to disregard them as a solution to the problem, because even African states have heavily relied on human rights, and newly independent states have heavily relied on human rights as something that carried the promise of a more just and a better world. But human rights doctrines also showed a certain kind of limitation. And as I have outlined, it is the private power of corporations that through globalization today immensely grew in power and influence, and basically can evade any obligations of human rights as they are addressed to protect the individual from the state and from state interference, but not from private interference. And it also does not really answer the question of collective rights and collective justice, because it puts a really strong emphasis on individual political rights, such as the right to assembly, the right to free opinion. And African states have traditionally, also in the conceptualizing of a right to development, more emphasized the right to self-determination, to permanent sovereignty over natural resources, and so forth. And interestingly enough, many African constitutions, for example, contain a right or an explicit mentioning of permanent sovereignty over natural resources, which belongs to the people of the state, which is emphasized in these provisions. And other African states, for example, such as Ghana, I know from the Ghanaian legal system, they also take natural resource law and legislation very seriously. It goes as far as having the death penalty on crimes such as illegal trade of gold, because the countries had made very detrimental experiences with the exploitation of resources. So you can see a slightly different conceptualization of human rights and what it means in a third world concept. It puts a stronger emphasis on collective rights. And by saying that, I would like to now engage in a conversation with you with regards to the question of poorer and richer states, of colonial and colonized states, or colonizer and decolonized, if this still holds value, or if you see a certain continuance in today's international affairs and relations. And for that, I yeah, I would like to firstly open up the floor for any questions, and then maybe pick a passage of the text if you have something in mind, or if you would like to further elaborate on something that you didn't understand, please point me out to that passage and we can discuss it. Otherwise, I've also just prepared something if you want to engage in something that I already thought about, and we can do that. But yes.
Perfect. Thank you so much, and turn your camera back on. Yes.
No, sorry.
Okay. Thank you so much. This is great. This is actually also a great opening for the discussion, I think. So if anyone else wants to start, if not, I already have so many questions.
I'll have a pen.
No, I think we can start with what you just said about how do we use the terms we use, or which terms are used. You know, are they just being replaced through new terms, but the existing power relations continue to exist in the same exploitative way, but just in new words, right? So I feel like, I think he has Anghie mentions this in both texts that he shared with us. And in this unedited article that you sent, he writes on page 10, the right to development attempted to represent the aspirations of the new international economical order in a language that would have better resonated with human rights, a language which had now become more widespread and powerful, the last utopia, etc. So my question was, yeah, and then again, he has a few pages later on page 18, he says, institutions such as the World Bank adapted the language of human rights to suggest that their own programs of good governance and the rule of law were better, etc. Like the sentence continues. But what was interesting to me is really that I was asking myself, which role does language play in the creation of law, you know? Or if we want to go further than that, which role does language play in the creation of a certain ideology, which is then the justifying narrative for the existing or the implemented power relations, right? Which I think is super interesting when Anghie goes back like all the way to 1530 to see how this ideology, how the colonizer ideology was implemented in the first place.
Yes. I mean, as a lawyer, language plays, I don't know, in any, scholarship, I would say, language plays a tremendous role. Even like, just to tell you a little bit about practice and about legal education in Germany. If you write an exam, it's really important if you write, how you phrase certain things. And you really have to make clear if you are now stating a fact. For example, if you're writing a judgment, it is really clear what is the fact and what is the legal opinion. So this differentiation between opinion and fact is already in our methodology. Only when it comes to academia, it is kind of change into subjectivity and objectivity, although no such thing exists. And that's why I liked also the excerpt from Anghie's interview. It also has something to do, it always has something to do with your biography or with your own thought process and how you position yourself within the system. And yes, Anghie, he writes, I mean, very strongly against human rights as a solution and as a very, I mean, human rights are not a Western concept, but how they were utilized and brought into legal doctrine was very Westernized. Because, I mean, even when we think about the question of racism in philosophy, and I started to write about justice, and then the suggestions I got from scholars was, why don't you read Kant? And then I was thinking to myself, well, if I read in a third world context, if I write in a third world context, and I use Kant with his ideas of justice and enlightenment, how can I disregard that enlightenment was also the starting phase of racism as we know it? Because we needed to have a justification why we treated certain people other, or that we treated certain people less than others, for example, in the colonies, you know. So legal thought and legal school was always connected with the time it was implemented. It doesn't mean that it doesn't have value today, and sovereignty is still a guiding concept, and it also is a concept that in the end also helped the decolonization. So it's this dilemma of having a set of rules that enabled your independence, self-determination, a right in international law that gave the foundation for independence, but that also enabled the occupation of certain territories by using doctrines and so forth. So it's always a question of language, yes, and the time a certain language was used and with the specific meaning it is coined and with the specific authority. And language and international law, as I said earlier, civilized, uncivilized. So this is a word that you read a lot still in international publications, the differentiation between civilized, uncivilized. And then maybe later it got replaced, as you mentioned also, Anghie states it in his texts, with developed and underdeveloped countries. But maybe it's time to move beyond the dichotomy of these binary thinkings, because and this is why I appreciate Anghie, is he points out that it's not state against state. Yes, it's poorer state versus richer states, but even in poorer states, you can see that certain dynamics and inequalities and colonial reproduction is happening, in the sense that it doesn't benefit all people. It benefits some, and liberation benefited some. And how can we achieve to bring everyone into the realm of benefiting from resources and from the idea of decolonization? This is why the strong emphasis on collective rights, which then again gets lost once a state acquires more power, such in the case of China and India, which are considered in international legal scholarship emerging powers, but reproducing internally the same power dynamics that can be witnessed in Western countries more and more, even also. And so I think this is a problem that we will all have to deal with, no matter where you are in the world, because our world is globalizing, and with the pandemic, we are already seeing the interconnectivity of economic relations, interstate relations, and how it's affecting every state.
Thank you so much. I like that you started the presentation with a quote from the interview where Anghie says that it's so personal, like his research is so personal to him. And interestingly, Mignolo said the same thing, if you remember, right? He said like he wrote his book when he finally had his like breakthrough in the career and left all the French structuralists and post-structuralists behind. He says he was like writing it from a place of rage and anger. So I think
me too.
yeah.
My word, me too. Because yes, if we look at the second text, the human rights and new international economic order, I've said already that international economic law is basically so important to ideas of decolonization, because in the end of the day, it's about assets and about access to certain resources. And in international investment law, which is the law, basically, in principle, we can summarize it as treaties between usually developed and developing countries that apply in a reciprocal way, but factually investment flows only go into one direction, which is already clear when you conclude these contracts. So the contracts are oftentimes binding a government for a long time to certain agreements of granting rights to foreign investors. So they are the beneficiaries of these contracts, but they can never be sued. They are the only entity that can ever sue a government, but the government could never sue a private investor. So there are certain asymmetries that already favor a certain kind of capital flow, I would say. And yeah, it was shaped in the 1950s when the first contract, funny enough, between Germany and Pakistan. So Germany was also an inventor of these contracts, which concluded in 1951. And from that on, we today have over 3,000 of these contracts. And only now is it reaching discourses in Western countries. I don't know if you all remember the discussions around TTIP. And oh my God, how can Germany enter, or the European Union, into such an agreement, where I was like, these agreements exist since the 50s, just never really affected us in a detrimental way because our investors were protected abroad, and foreign investors coming to Germany didn't need much protection in that sense, because it was considered a good governance state. The language again, which is, I mean, it's debatable. It's good governance. Is it something that is maybe a term that hides a certain intention of an international financial institution and the strong emphasis on democracy, which is oftentimes a precondition of the IMF and the World Bank to grant loans or to grant financial incentives? Is that a post-colonial mission? Or is it maybe more just if we have contracts between China and African states, and China appearing as we never colonized you, so we are the better partner. We create win-win situations, and just enforcing a completely different rhetoric, only by rhetoric and soft powers, charming African countries with this non-colonial language. Instead of aid and donors, they speak of partnerships, win-win cooperation, and never interfere in the internal affairs of African states with good governance and with democracy. And they have a strong stance of non-interference. So is that the better and more just way and solution? It's open for debate, but this is, I think, the question that we will have to deal with if we really want to achieve and move towards a truly post-colonial law. It's going beyond language, I think, because language can only be so and so much, but really implementing ideas and concepts of global justice that benefits the people as a whole. So the strong emphasis on peoples instead of states, because despotic power can nevertheless halt any development achievements or development. And then development, is that something that we should strive for, or is it again just a replication of wanting to achieve civilization? I mean, this is all open questions, which I also do not have answers to per se, but we see a continuance of certain language, then transforming into other vocabulary. I also see, like in modern times, a strong emphasis on culture as an argument in law, in other fields of research. But isn't culture just another term for we don't deem you civilized enough to be within our culture? What do you think, guys?
Yes.
Do you have any questions?
Let's open up the discussion for further comments. Antonio.
Yes, thank you. Thank you, Anna. Thank you, Katarina. I was just thinking right now, I don't know if nowadays, actually now, we talk about so much about civilization and progress. Now, maybe now there is this split about mere survival. Now with the coronavirus, you see some Western countries, Europe and Canada and the United States that got all the vaccines with some special deals with the contract with some multinationals, and you see that the global South is just with few leverage to have access to those vaccines. And I mean, France has 4 times the vaccine of the population. I guess the same in Germany or in Canada or the United States, and many countries in the South do not have any access to that. So in a way, what I'm pointing here is maybe it would be good to see also the right now in our times, it's along with civilization, culture is mere survival. I mean, who's going to survive? Even the climate crisis, and we have this kind of divide with states, society, and the I was wondering, and the corporation. Then you have how do they use this?
Thank you. Very, very, very interesting and crucial point, and something that I've also read on recently with the vaccines, and how it will maybe influence the discourse. And also climate justice. It is also an important, who dictates what does it mean and who has a right to development or industrialization. Do we just say, well, we now all start at zero when this was not the case? So do we have to take power history and the history of power into consideration when dealing with these issues? And now that you're speaking of the vaccine, so it is correct, the vaccine, now the question of poorer and richer states has entered health diplomacy. And we now have new powers such as I've already mentioned, the BRICS, especially China and India, entering the international arena, also actively engaging. So the thing is, the global South is not being silent. They're actively engaging and trying to reshape and participate in the system. So they're not necessarily contesting it. Every time third world countries participate in lawmaking, in international law, it's always seen as a crisis, legitimacy crisis, and maybe it will question now the world order, but maybe it's just reshaping it and renegotiating it on new terms, Who says that what is has to be and is the way forward? Who says that things can change? So this is what I wanted to for you to have as a takeaway message. Things can change, laws can change. But with regards to health diplomacy, we see now a lot of new actors and emerging powers entering the arena. And especially China is engaging in a lot of health diplomacy, especially with African countries, and has guaranteed to many African countries, has already assisted them in free masks, free test machinery, equipment, healthcare teams. When I was traveling to Ghana, you could spot all the medical teams that were deployed to different African countries, and also with agreements of, you know, giving the vaccine for free to African countries. Even the president's wife, of Xi Jinping's wife, has already made big donations. China's encouraged private actors to make big donations. So Africa has seen another scramble for influence and for power. But we can also witness that African states have had enough of Western dictation of terms and conditions, and are now moving to other, to other partnerships and away from this traditional North-South relations. And China is making it has a smart tactic and a smart approach to it, because it's really it's really approaching it completely different and from a more eye-level point of departure, at least in its rhetoric and in its gestures. What that kind of soft power then means is another story. And one could debate if this could be another neocolonialism. I don't see the necessary foundation for it if we argue with this concept of sovereignty, because, as I've said, every state is sovereign, so no African state has to enter into these agreements. No African state has to accept gifts or free vaccination, but they're in a need, so maybe there is also, a certain pressure. State decisions aren't always free from social pressure, as we have heard in the quote from Abi Saab. So it remains to be seen how, it will develop, and how old powers maybe will reactivate and will, try to maintain their influence in Africa, as it is an important, distributor for natural resources. We all have a smartphone, we all need the minerals. So yes, it's remains to be seen how this will further develop, but new partnerships are on the rise. And my question was, will it bring us to will we see a world that is more just in that sense?
Can anyone who is not whoever is not talking should turn off their microphones, but now you should all turn them on and ask questions.
Yes. Or comments, any kind of input. Right. I'm always open for input. Unlike other lawyers, I don't think that I have the objectivity or that I have exclusive access to.
Yes. Patrick McNamara.
Yes, I thank you for letting me join your group. I didn't do the readings. I didn't get them, but I'm looking forward to I've looked them up since then. And I'm a historian of Latin America who also has gotten out of the archives, and I'm doing much more on human rights now. Mm-hmm. And, I work as an asylum country conditions expert. Mm-hmm. For people from Mexico and El Salvador. Mm-hmm. But one thing I was struck by your presentation is like you didn't use the word neoliberalism at all. Mm-hmm. And I don't know if the readings discuss this today either. But it seems to me in institutions like the United Nations, where nation state sovereignty is still the organizing principle, mm-hmm. and isn't violated at all. on issues like internal displacement or other things, that the neoliberal agreements around giving up economic sovereignty decision making is perhaps a model for decision making around human rights. And in other words, instead of having nation states agree on principles that are written and established, they could approach a more an agreement that deals with conflicts in a way that neoliberal conflicts around economic, around the free trade agreements and things, where states don't have their own sovereignty. I think that we are still behind in relying on nation states. Sure. The last, so if you're interested in commenting on that, I guess, and how neoliberalism fits with
yes,
I just want to apologize for not turning on my microphone, but I have a bad case of COVID here today, and I thought it would be more of a webinar, so I'm not presentable, I guess. Or
don't worry, and many thanks for your input. Neoliberalism, of course, if you read the New International Economic Order piece by Antony Anghie, it touches upon that. It was just, I was already over time, and I thought maybe cut it short, that we have some time for questions, but that is exactly the issue with the, economic sovereignty, or neoliberalism as a momentum after the Cold War ended in the 1990s. You also see a sharp rise in international agreements, also bilateral investment agreements, also with the participation of, developing countries or states of the global south, as they were promised, if you, engage in that system, prosperity will follow. And a lot was dictated by financial institutions that are then conversely not bound by human rights. So maybe a solution could be to achieve accountability for institutions as well as states, because if you implement economic policies and then in many cases there's evidence that it was to the detriment of the population, so how do you deal with that? Who's responsible? You do not have a responsible entity because it was done under the roof of an international organization that cannot be held accountable. Then, also flexibility could be a solution. I mean, this kind of flexibility that you're mentioning is already a strategy that is implemented by new emerging powers such as China, Russia, South Africa, and so forth, that they grant their partners more flexibility in drafting the contracts and drafting maybe the conditions, that you don't say we have these pre-coined terms such as good governance and we pour our understanding into it, but that we can make it more, country specific, that it's more tailored. So neoliberalism was, in the Anghie text, it's especially criticized in the sense that financial institutions created a web of dependencies. And it is true, I dealt with international financial law and regulation in Africa. I also was invited by the African Union to advise on that matter. And it's a very complex issue, financial regulation, because you have certain entities like the G20 that basically, and other forms, the G7 and so forth, that kind of dictate certain policies that are recommendations, but in a way they are binding, because then you might not get a loan if you do not abide to this policy and agreement and so forth. So there is always a backdoor of influence being carried out by Western institutions and states. So if one could tackle these dependencies, or maybe just formulate conditionalities to the benefit of, you know, the people in the countries, maybe, I mean, that's could be an idea, but it is certainly something also very dominant in third world scholarship, third world approaches to international law, criticizing the neoliberal developments that started in the 1990s. And funny enough, now we're seeing a more, maybe a withdrawal from this, neoliberalism and also collective engagement. More states are enacting protectionist measures, which goes more back to the classical ideas of international law.
Yes, thank you.
I hope that,
I'm just trying to, Mexico loves human rights reports. The government will accept anyone who's critical of the government and violating human rights, and then never does anything about it. I mean, they work better than anybody, it seems to me, on playing the human rights performance. So I like what thank you for your answer.
You're welcome.
I'll go back to mute.
Just before we have the next question and the next comment by Juan Blanco, I wanted to say there's a little debate in the chat about how to get the texts. I've seen that there are new faces and new names this week, which is amazing. Please feel free to just either send me your email address or send me an email, and then I'll send you the text, or I'll put you in the email list for all the upcoming sessions. Okay, Juan Blanco.
Hello, let me introduce myself. I am a historian and Puerto Rican, so these issues are very pertinent to us, especially the role of national oligarchies of independent or distinct states in achieving real fruition of their independence. And looking back at the creation of the thing called Latin America, which is a very strange construct, because it's presented as an expression of the independence of those countries. But in fact, what it represents is the success of a French measure to control the oligarchies, to make them culturally dependent on them. And one finds that the oligarchies are the executors par excellence of colonialism in their own country. They reinvented, they apply it in new and distinct ways, and they assure that any effort in their country to escape is thwarted. Being from Puerto Rico, that's especially evident because, of course, the United States invaded the country under the hypocrite notion that they were liberating Puerto Rico from Spanish colonialism. And in fact, you have a terrible government, a regime rather, that is it thwarts any effort of the people to express their sovereign identity by pushing it in other areas. I'm very worried about the current government in the United States because it is a perfect example of how any kind of desire for real change is thwarted by wannabe lookalikes that reinterpret the actual substance of that desire for real sovereignty into something that simply pushes the colony closer into the colonial power. So I'd like to ask you to look at your discussion from that perspective. Of course, these observations can also be made.
No, 100%. Actually, I read a book on the situation in natural resource power and influence, or in Angola, and it's a very similar observation done by the author Lucy Corkin. She stated that you have the traditional partners such as Europe and the US entering into Angola, and Angola is rich in natural resources, and it's one of the countries where the living costs are extremely high. Like for a cappuccino, you pay like $20 or something like this. So it is an extremely a rich elite in this country that can afford these kinds of things. And then Angola is like a very poor country, on the other hand, when you look at the majority of the population. And she analyzed whether the entering of new powers such as China and India could actually benefit the state because it could leverage its resources But then she concluded that because of the, in your case, oligarch power in Angola, it's a certain elite and government that she calls it despotic power, which never translate, which they could leverage. They were successful in leveraging. They have the US now and they have China, so they can, leverage the resource. But it didn't translate into benefiting the population. So basically the power accumulated at the top and there was no trickle down effect of this power. And this is again something that Antony Anghie also criticizes, that a lot of times it's a replication of old structures. So it might be time to let go of the of the idea of the colonized and the colonizer, because it's not as simple as that. There are many actors that can maybe be on the side of the colonized, and then as soon as they gain power, there is a different dynamic entering the terrain. As far as I understood you correctly, at least I've seen similar things in many African states as well, and you have inequalities that are so striking in many developing countries in Africa and beyond.
Thank you.
Yanis, do you want to pose your questions and into the general debate?
Yes, there were a couple of comments additional to the corollary to this discussion, that these land value or rental markup that Anna was describing in Angola was happening in the 19th century in Alaska, in the gold rush in Klondike. You can get an egg and ham breakfast for $240. Of course, they could pay it because they were next to the gold. And similar thing happened also in the Dakotas here in the US. I think when there was this oil extraction boom that happened, and the people were flocking there. So there was this like inflation of land values. It didn't persist, but as a phenomenon, it happened. Now my question was to Juan in terms of Puerto Rico sovereignty, in relating to the question that it's very hot today, whether Puerto Rico should be annexed to the United States, which is a plan that the Democrats want to push because they want to add senators.
Well, this entire scenario it really expresses the obscenity of the United States relationship with Puerto Rico. I'm in favor of complete independence. Puerto Rico is a country that can support independence very well. It's called Puerto Rico because it's a country that's rich in resources, even though the United States likes to deny it, and it's disgusting that the United States will not accept a petitions by their lackey pro-annexation group when it comes from them. But when it comes to getting a few miserable seats in the Senate, they're willing to contemplate it. This is the epitome of colonial exploitation, as if Puerto Ricans don't exist. And of course, what is motivating this? The gradual replacement of the Puerto Rican people by emigre Cuban colonial types, whether from Cuba, Dominican Republic, Venezuela, Colombia, or expats from the United States. These people that most people in Puerto Rico boycott any of the plebiscites on statehood. Puerto Ricans are immensely nationalist people. In fact, what statehood means in Puerto Rico, federalism, is completely incompatible with what it means in the United States. It in fact comes from 19th century Spanish culture, during which time federalism was based on the Swiss model of confederation, where of course, Switzerland is a country that has 4 linguistic groups. So it's not like most nation states that have one country, one people, one language. And the idea in Spain is that was a way of addressing the Catalan speaking, the Basque speaking, the Galician speaking groups in the country, so that the country would have 4 different, well, of course, in the case of Puerto Rico in the 20th century, most people don't speak English. They assume, the statehooders lead their people to believe that, well, somehow Puerto Rico can become a state and continue to be a Spanish-speaking country. No way, because that's not the nature of federalism in the United States. It is one lie compounded on the other. Puerto Rico is a quintessence of all the aspects of how colonial depredation functions in terms of eliminating the population. In fact, I'm hoping to present a paper at the UN where I want to lay out clearly that the presence of the United States in Puerto Rico since its moment of arrival has been a form of institutionalized genocide at every level, beginning with the fact that the Treaty of Paris that ceded for Spain to cede Puerto Rico to the United States is completely illegal because Puerto Rico at that time was a self-governing entity under Spain. In fact, its Charter of Autonomy was used in Spain itself as a model for the Constitution of 1978, which gives autonomy to its various regions. So there's a political culture in Puerto Rico that exists that is negated by the United States. And the fact that it succeeds in doing so with a very facile discussion on what the political culture of Puerto Rico should be, indicates just how much the United States is the epitome of a colonizing imperial power. The two cases that you gave, Yanis, of Alaska and Colorado, they are really very interesting to look within the context of the Anglo-American form of internal imperialism that has functioned so well, to the point where it has annihilated local populations. And I'd also like to say that what one sees in the United States, and it's a continuation of the observation I made before, is that the United States is a moiety in terms of its power play. It's clear that there is a division between black and white. But this is a division that's very interesting in terms of the discourse of the United States, because it provides the official self and the official other, and they complement one another, to the point where there is no possibility of getting a foot in edgewise of another alternative viewpoint by other peoples or peoples that want to define themselves in their own terms in other ways, whether they're Hispanic or they're indigenous. I think that the United States defined imperialism and colonialism in its most modern form, because it succeeded where all imperial powers want to go, in that internalizing, subordinating these exterior territories into the national center. It's like what France wanted to do with Algeria and did not succeed, but defined the model, so to speak. The US picked up on that. And it's also interesting to see the role of the British colonial mechanisms operating in the United States. There's a lot to be learned from the fact that Vice President Harris is of Anglo-Indian origin. It'd be good to look at the role of Anglo-Indians in the British Empire in being the administrators of colonialism in Africa. Gandhi is an interesting character because he spent a significant part of his life in South Africa. And I think his political consciousness was developed by that experience in South Africa to see the modalities of colonialism as an operating form of government. And that unfortunately has not been addressed sufficiently by the formation of the United Nations or the creation of these so-called independent states, because everything goes back to oligarchies of different form and format that basically replicate the colonized format in their own countries, in their own communities in a very specific way. And going back to Puerto Rico, it's very clear to see that. Very, very clear.
I mean, there are many mechanisms in international law that prevent us from debating and actually, of states insisting on decolonization today, because within the platform, within the Organization of the United Nations, it was stated that the decolonization mission has ended, it has been completed, so there is no further need, which was an explicit reference to, so this is what you get, but this is it, no more, And we see it in the International Court of Justice today, that still cases of issues that are intrinsically colonial in their nature are still being debated and fought at the International Court of Justice. Only, how you rightfully say, it's again a question of who has the power to write the laws and to implement them. And if we take the International Court of Justice, for example, the United States, in case they would ever be convicted, such as in the Nicaragua case, what could they do? They could just not implement the judgment. And then you have one more option. You could go to the United Nations Security Council. And who has a veto power in the Security Council? The United States. So technically, no judgment could ever be, implemented against the wishes and the ideas and the pursuit and the strategies of the United Nations, of the United States. In the same way, they could never be brought in front of the International Criminal Court. So there are a lot of mechanisms in place still today that still supports a certain power dynamic. And the United States is certainly the #1 power in the world, in the old world as we saw it. That's why, and that's my hypothesis, international legal scholarship is always speaking about crisis as soon as it changes, that it might be contested that the US is the, you know, the #1 world power and democratic leader and so forth. So a lot of it can be coined Western anxieties of how a new world would look like. Not to say that, you know, formerly colonized states do not replicate. This is not to say that they're innocent, the innocent partaker. We always have to look at the specificities of a case in order to understand the power relations and the dynamics. But power shapes law. We are not in a vacuum. It governs our social relations, our everyday relations, interstate relations. And there is hope because laws can change.
There's almost no more time. But I think, Yuri, you can ask your last question and then we can finish. This was already like such a beautiful sentence to end the session. But yeah. I think
I feel that it kind of covered by this final statement in a way.
Say again?
I think my question was more or less covered by this final statement that I also feel it's like a great closing. So I think
change is always an option. Nothing has to stay the way it is.
Well, so let us stay curious about what is going to happen. What are going to be the new ideologies we will have to live with? How much power we can have or how much power Anna can have in changing everything. I would be very much looking forward to that. And in the meantime, I just want to say we will meet again in 2 weeks for our 7th session, which will be about the decolonization of the Latin American literary canon, together with a Colombian colleague, Juan Felipe Castro Maldonado, and Professor Claudia Hammerschmidt from the University of Jena. And then, so we will discuss 2 different texts, one by René Depestre and the other one by Jerome Branch, who will also join us for the reading group at a later session. In any case, stay tuned. I will send you the text via email. So if you haven't sent me your email addresses yet, you can send them to me in the chat or per email, and I will add you to the list. And I'm looking forward to see you all again. Thank you, Anna. This was a wonderful session. Thank you so much. So
and if anyone has questions or wants to debate something, because I love to debate these issues, please reach out to me anytime. It's really something close to my heart. And I read about it. I think about it all the time. And just engage. I would be happy. And thank you, Katharina, for, you know, providing such a platform to discuss these issues, because it's interesting. And I'm always surprised to see how many people are interested in it. And the inputs, that the comments, they were excellent. They also stimulated, you know, my want to research more in these directions. And yes, thank you so much to everyone, and hopefully see you again.
Thank you so much. Wonderful. This is what we're here for.
Okay.
See you in 2 weeks.
Thank
Bye.
You. Bye.